Good afternoon. Welcome to our webinar. We're going to give everybody just a minute to get in, and then we will get started. Welcome to everyone for our webinar on voting rights law. My name is Laura Beckman, and I'm with the Public Interest Law section of the Florida Bar. We're happy to host this webinar for you today. And I'm proud to introduce Nancy Abudu, who will be our speaker for today. Nancy is the Deputy Legal Director for the Southern Poverty Law Center's Voting Rights Practice Group. Prior to joining the Southern Poverty Law Center, Nancy was the Legal Director for the ACLU of Florida and a Senior Staff Attorney with the ACLU's Voting Rights Project. She's litigated a variety of civil rights and civil liberties issues in federal and state court, including legal challenges to state felon disenfranchisement, proof of citizenship, and voter photo ID laws. And she's pushed for greater enforcement of the Voting Rights Act, the National Voter Registration Act, Help America Vote Act, and other federal laws. Prior to working with the ACLU and the Southern Poverty Law Center, Nancy's also been a staff attorney with the 11th Circuit Court of Appeals in Atlanta and an associate at Skadden Arps, Slate, Megan & Flom in New York. She served as an international election observer in Albania and is a member of the ABA's advisory committee to the Standing Committee on Election Law. She received her BA from Columbia University and her JD from Tulane Law School. She's admitted to practice in Florida, Georgia, New York, the United States Supreme Court, and several other federal and state courts. We're thrilled to have Nancy join us today, and she's clearly an expert on the subject about which you're about to hear. So we thank her very much for taking the time to speak to our group today. And without further ado, I present Nancy.
All right. Well, thank you so much, Laura. I really appreciate that introduction. And I also want to thank John Fenno, who's been working behind the scenes to publicize and organize this webinar. So thank you, John, as well as those who worked with him and Laura to make this happen. And of course, I want to thank all of you who took the time out of your busy schedules to participate in this webinar on voting rights, especially during this very critical phase in our country and in our democracy. So I am looking forward to your questions and comments as we engage in what I hope will also include a dialogue about how do we make our democracy work for everyone. So obviously, I'm with the Southern Poverty Law Center now. For those of you who are familiar with the SPLC, we are a nonprofit organization based in Montgomery, Alabama, but with regional offices pretty much in all of the main 5 Deep South states. And our practice groups range from immigrant justice to criminal justice, children's rights. But SPLC just this year launched a voting rights practice group so that the organization could really put its resources and muscle behind protecting some of the rights that I'm going to talk about today. Florida, of course, is one of our coverage states. It's a state where I've been living for several years, and so it's also very close to me. And some of the issues that I'm going to mention, as well as the litigation, I have been involved in my prior role as the legal director for the ACLU of Florida. So again, I welcome any questions you have, and if there's anything that I'm unable to answer today, I do commit to getting the answer to you all as quickly as possible. So I wanted to just provide you all with an overview of today's presentation. These are going to be the 4 main topics that we discuss, and I will go through them. Florida's Amendment 4 and rights restoration efforts. As many of you know, in November 2018, Florida voters passed Amendment 4, which is known as the Voter Restoration Act, to essentially re-enfranchise what's estimated as 1.4 to 1.6 million people. It's a historic passage in terms of the franchise, and so of course I'm going to spend a little bit more time on that topic than some of the others. But I do want to provide you some information in terms of the current landscape regarding redistricting, election administration, which is going to cover issues like voter registration, voter purges. We're going to talk a little bit about vote by mail, which was formerly known as absentee voting, and in some states still is only absentee voting. And then an issue that I don't think attorneys, especially litigators, perhaps think enough about, which is community engagement and how do we lend our litigation skills, when possible, to get out the vote mobilization efforts. Now, these primary topics, of course, do not cover the total breadth of election law in the current landscape. There's, redistricting litigation in North Carolina and Alabama that's gotten a lot of attention. There's been progressive legislation passed in places like Louisiana and Alabama to expand the franchise to those with criminal convictions. There's been litigation surrounding voter registration extension, the deadline extension, primarily related to the fact that Florida is caught up in the hurricane season, and that usually happens around election time. And then we got a great win recently, actually, in federal court related to the expansion of Spanish language coverage for purposes of making sure that those for whom English is not their first or primary language are still able to educate themselves about who and what's on the ballot and cast a knowing ballot. So again, there are a host of issues that we could discuss, and I'm happy to touch upon some of those in the Q&A section. But again, these are the 4 primary issues that we're going to focus on today. So without further ado, we'll get started with Florida's Amendment 4 and rights restoration. And in this section, I want to provide you all a little bit more history about felon disfranchisement, where it comes from, how it's played out in Florida. Because of Amendment 4's passage, we have to discuss, of course, the ballot initiative process in Florida. Florida is one of, I believe, about 24 states that has a ballot initiative process that allows folks to put things or vote things into their state constitutions. And in several states, they can actually propose statutes. So that is not totally unique, but definitely not the entire country in terms of allowing voters to have a say in policies. A little bit about litigation that was related to Amendment 4 and the impact that the court's decision might have had in terms of people or the general public's understanding of the impact of felon disfranchisement in Florida in particular. And then I want to touch upon some of the bills that were introduced, passed, and/or proposed and failed that I believe were directly related to the success of Amendment 4. So we'll get started a little bit with the history. So I provided you all the section from the 14th Amendment. It actually should be Section 2. I'll correct that, but I'll just read it. So it's when the right to vote is denied to any of the male inhabitants or in any way abridged, except for participation in rebellion or other crime, the basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state. Now, we already know that several of these provisions in this section are no longer valid. Men are not the only ones anymore who can vote, and the voting age has also been reduced. But we do know that this provision that talks about except for participation in rebellion or other crime has really been the basis for the creation and expansion in many states of felon disfranchisement laws. And in 1974, the Supreme Court relied upon that provision, Section 2 of the 14th Amendment, in ruling in a case out of California challenging that state's felon disfranchisement laws, that the exclusion of felons from the vote has an affirmative sanction in Section 2 of the 14th Amendment, a sanction which was not present in the case of other restrictions on the franchise which were invalidated in other cases. And so that I think goes to the court's recognition that there was this provision, and I would argue it's over-reliance on this provision in terms of allowing felon disfranchisement laws to exist, and also being less open to hearing or ruling in cases that focus on the re-enfranchisement process, which is part of why Amendment 4 was so important. So to give you a little bit more in terms of the history, the timing of the 14th Amendment's language in Section 2, and of course the emancipation of slaves, was no coincidence. Although African Americans didn't have the right to vote until passage of the 15th Amendment in 1870, the foundation of election laws in America and in Florida have always focused on wealth and race. So one could only vote if they were male, they were white, and a landowner. And we see a little bit of that in the language of Section 2 of the 14th Amendment that I just quoted. And then we know that wealth was an important criterion for a very long time. And some would argue still today in terms of really being able to effectively access the ballot. So while it is true that felon disfranchisement laws existed in the constitutions of several states before emancipation, and that was brought over from the common law, this idea that if you are convicted or commit a crime, that you have broken a social contract and therefore really are not entitled to all of the rights and privileges of citizenship, that there can be no question that the expanded scope and impact of those laws did change following the passage of the 14th and 15th Amendments, and were motivated in large part by an effort to make sure that newly enfranchised former slaves would not wield nearly the same political power as their counterparts, their white counterparts, or even in proportion to their population size, given that in some places, counties or jurisdictions, the slave population significantly outnumbered the white population. So Florida first adopted its constitution in 1838. But it was the 1845 Constitution that allowed for the disfranchisement of someone convicted of a crime. And the felon disfranchisement provision, in some form or fashion, has remained in every single version of Florida's Constitution since. So if there was any confusion on the part of courts as to, again, the racial and economic motivation behind Florida's disenfranchisement law, I think we just simply cannot ignore the relationship between the end of the Civil War, the emancipation of African Americans, and then Florida's adoption in 1868 of a revised felony voting ban. In a case called Johnson v. Bush in 2005, the 11th Circuit actually relied heavily on the fact that when the 1868 Constitution was enacted, there were Black and white delegates from Florida to the post-Civil War convention who voted to include a felon disenfranchisement provision in the Constitution, which, according to the 11th Circuit, was enough reason to believe that it couldn't have possibly been motivated by racial animus, especially given the federal government's oversight during that time of Reconstruction. However, some would argue that the court essentially ignored the fact that the 1868 Constitution also produced a legislative scheme that diminished the voting strength of African American counties, such that Black members of the delegation that the court viewed as supporting criminal disenfranchisement would actually no longer be part of future delegations for decades to come. So the impact of racial animus ran deep, and I think it's unfathomable, really, for the court to continue to disregard the tremendous role that racism played in the continuation, if not in the original enactment, of Florida's felon disfranchisement law. So like many policies that appear facially benign, like some would say today's voter ID laws and voter purge laws, I don't think there can be any legitimate denial of their impact, or felon disfranchisement laws impact on racial minorities and poor people. As I'll mention a little later, it was estimated that 10% of Florida's voting age population was disenfranchised due to a criminal conviction. And of course, when we couple that with the racial bias in our criminal justice system, there should be no surprise really that African Americans and other racial minorities are the ones who are most impacted. So unfortunately, it's of course always proving or requiring plaintiffs to prove what some would agree is universally understood, which is that America has a long history, unfortunately, of racism and classism that has seeped its way into the very fabric of our electoral systems. So the contemporaneous evidence of racial discrimination surrounding the adoption of Florida's 1868 Constitution, even though that wasn't enough to protect the fundamental right from being eroded in this way, I think that we have to again think about the context, the historical context. You also have the creation of Black codes, which were specifically designed to convert former slaves into convicts, and that goes to the 13th Amendment's caveat or exception or carve out for those who are convicted of a crime in terms of who can still be under some kind of slave system. And so again, we see that there is historical context that I don't think the court took considered enough in terms of really looking at the validity or legality today, at least, of these laws. So to me, there's no overcoming the odious origin, as some plaintiffs have argued, of Florida's felon disfranchisement law, especially as I said, over 10% of Florida's voting age population was affected, disproportionately Black and or poor. And that in Florida, there was a permanent ban, essentially, and that you would have to go through a clemency process to get your rights restored, which I'll talk about in a little bit more detail coming up. So therefore, while federal and state courts considering the history and motivation behind felony disfranchisement laws have concluded that because Blacks couldn't vote, then those provisions couldn't have possibly been adopted for a racially discriminatory purpose. Again, race and class have gone almost hand in hand in ensuring that poor Black and brown people never have a strong voice in our election system. So in terms of talking a little bit about the litigation, as I mentioned, you had a case, Han v. Scott, that was filed. And just as a little bit of background, the Sentencing Project estimated that in 2016, around 6.1 million people, about 2.5% of the US voting age population, was disfranchised based on a felony conviction. And again, Florida alone accounted for an estimated 1.6 million of those voters. So while that number alone is astronomical and alarming, again, when you couple it with the fact that in Florida, we've had elections that have been won by less than 1% in terms of the margin, the significance of excluding such a huge population of the electorate is even more stark. So in 2017, there was a lawsuit filed. 2018, a decision reached in the case Han v. Scott. This was a case in which people with criminal convictions who had applied through the clemency process for rights restoration were either denied or still waiting years later to find out whether or not they would even have a hearing related to their application, sued over the clemency procedures. And under Florida's previous law, those who had a criminal conviction who wanted to get their civil rights restored, not just their voting rights, but when we talk specifically about voting rights, they had to first satisfy all of the terms of their sentence, meaning prison, parole, probation, and they also had to satisfy financial obligations. And then under Governor Scott, there was also a 5 or 7 year waiting period period imposed based on your offense or the nature of your crime. And so you can imagine that there was a huge backlog. You had folks who had been out, had finished their sentences out in the community, having children, paying their taxes, etc., who were still waiting for years and sometimes, for some decades just to get their voting rights restored. And so in Han v. Scott, the plaintiffs argue that the state's clemency process violated the 14th Amendment's Equal Protection Clause and the First Amendment because of the unbridled discretion that the state exercised in denying people restoration of their voting rights, especially when it came to exercising political speech. And so, with the clemency process, there was no deadline by which a decision as to an application had to be made. There were no clear guidelines given as to how those decisions could be made. So the record in that case showed that there definitely was a disparity. If folks aligned themselves with a political party or were convicted of certain crimes versus others, the outcomes were vastly different. And so that is why the plaintiffs argued that this unbridled discretion really didn't give anyone any kind of clear guidance in terms of what they could do to present the best case for why their rights should be restored, and also made it very difficult to balance or to serve as a check for the governor clemency process in terms of making sure that it was being used in a fair, equitable manner for everyone who was appearing before the clemency board. So the district court, and I have the first quote here from the district court, found that the plaintiffs' right to free association and right to free expression were denied under what the court recognized as a fatally flawed scheme of unfettered discretion that was contaminated by the risk of viewpoint discrimination. And so this was a case, a decision from Judge Mark Walker in the Northern District of Florida, who, again, after looking closely at the record, showing the disparity, showing the lack of guidance or guidelines, came to this conclusion. And so the district court permanently enjoined the state executive clemency board from enforcing the clemency process, which again the court viewed as an unconstitutional vote restoration scheme. And the court also ordered the state to promulgate specific and neutral criteria to direct vote restoration decisions, along with meaningful, specific, and expeditious time constraints. So the first part in terms of the specific and neutral criteria, again, was to at least give people some notice as to how this process was going to unfold, to make sure that everyone was being treated equally and that decisions would eventually be made so that people weren't in a continuing holding pattern, waiting again to find out if they were going to even get a hearing, let alone have their application granted or rejected. So I would say, unfortunately, the 11th Circuit stayed the district court's decision and determined that the appellees, and also this is quoted in the slide, that all the appellees have offered in this case is a risk, that standardless determinations could lead to impermissible discrimination, and that is not enough to show a discriminatory purpose or effect. So some would argue that the court's decision of staying the district court's ruling was a forecast of a possible reversal on appeal, although the case, I believe, is now moot as the plaintiffs believe, given the passage of Amendment 4 and the fact that all of the plaintiffs, at least in the Han v. Scott case, even with some of the changes we'll talk about a little bit later, should still be eligible for automatic restoration of their voting rights. So to talk a little bit about, well, first, before we move on to this slide, if you all have any questions, again, as we move from the different topics, feel free to interject. But again, as I mentioned earlier, Florida is one of about 34 states or so that have a ballot initiative process. And in Florida, in order to get an initiative on the ballot, it's no easy task. First, supporters of the measure have to secure right now at least 766,200 signatures, and these signatures have to come from at least 14 of Florida's current 27 congressional districts. The petition signatures are only valid for 2 years from the date they were signed. So reaching that numerical threshold in a timely manner, of course, is of serious essence. You can imagine that this can be a very expensive process, whether you're paying petition gatherers or volunteers, in terms of just getting out there and making sure you're reaching as many people to get the signatures. And even though 766,000 is the magic number, to avoid folks who might not be properly registered to vote, or if there are any problems with the petitions, or if some of them expire, the goal is to get a lot more than that. So I believe in the Amendment 4 situation, or about 1 million signatures were collected, and even discounting some of those that weren't valid, the proponents of the amendment definitely satisfied this number in terms of the first step. Again, in terms of making sure that the petitions are valid, and then once you satisfy those two things, then you go to the state Supreme Court that has to also review the language to make sure that it's not misleading or otherwise confusing to voters. And then this situation, the Supreme Court did approve the language and found that it clearly informed voters as to what the nature and scope of the law was, and that they had a clear understanding in order to make an informed decision as to whether or not to vote yes or no on the initiative. And so once you pass that litigation hurdle, then it gets placed on the ballot. And I would say the really hard work begins of getting enough signatures to actually get it passed, which currently is at least 60% of the votes. So Amendment 4. As a little bit of background, this issue, again, 1868 Constitution that revised Florida's felon disfranchisement law, but I would say that it was really the 2000 election where people really understood the impact, not only of Florida's felon disfranchisement law, but the impact of these laws around the country. And so for at least 15 years, numerous bills in Florida, as well as in other states, have been introduced to re-enfranchise voters automatically. And the Florida legislature didn't do anything. They never really considered some of these bills. Some of them died before they even got to their second or third committee, or nothing was done. And so in 2018, I think Florida citizens decided that they had had enough with waiting on the legislature to enact laws that reflected the progress that our state has made on several fronts, and that were more in line with the values of most voters, Republicans and Democrats alike. And the beauty of Amendment 4 is that its passage really was bipartisan. This is a state where, even though you have a majority of Democrats registered than Republicans, it was really the Republicans voters who helped to get Amendment 4 across the finish line. So I think it's a wonderful illustration of the fact that, regardless of political affiliation, there are just certain issues that go beyond that and are just a matter of fairness and moving us as a nation forward. And so a lot of national and state-based civil rights groups launched a major campaign in Florida to get the ballot initiative on, passed, or so that we can amend our Constitution to allow for automatic restoration of voting rights, rather than forcing people to go through what the District Court in Hand v. Scott recognized as a completely discretionary, arbitrary clemency process. So what I have for you on this slide is the language of Amendment 4, which provides the first part, that no person convicted of a felony or adjudicated in this or any other state to be mentally incompetent shall be qualified to vote or hold office until restoration of civil rights or removal of disability. And then it creates an exception that, the exceptions, as we'll see in subsection 4, that any disqualification from voting arising from a felony conviction shall terminate, and voting rights shall be restored upon completion of all terms of sentence, including parole and probation. And then the carve-outs when it comes to Amendment 4 is that anyone convicted of murder or felony sexual offense must still go through the clemency process. So they are not eligible for automatic restoration. So when folks say, oh, it's everyone, it's not everyone. It's a huge, significant number of people with felony convictions, as those convicted of murder and felony sexual offenses are a smaller number, but it's still important to note that these two carve-outs do exist. And so, working under the umbrella of the Florida Rights Restoration Coalition and several other organizations, raised millions of dollars, really, in order to mount the necessary public education campaign to recruit enough petition gatherers, both paid and volunteer, to secure advertisements on television and billboards, organizing community meetings, and really doing whatever else was necessary to get out the vote and make sure that people voted yes on Amendment 4. So hopefully you saw a lot of stickers and signs, you saw people standing outside of your local grocery store, libraries, and other places encouraging you to vote yes on Amendment 4. And so with this hard work and the tremendous amount of support from voters, 64.5% of Floridians voted in favor of the initiative. And that extra 4.5%, I would say, is important because remember, again, we only needed 60% for the passage. And so it was great to not only meet that, but to go a little bit beyond that threshold. And as I mentioned earlier, that this was a bipartisan supported effort. So notably, as we know, that the Republicans won the governorship, they won a majority of legislative seats, the state judicial seats, and also passed Amendment 4. So I think, it's important to recognize, as some try to do, to cast this as, something that's only going to benefit one political party. Well, the actual voters didn't see it that way, which is why they collectively voted in support of this initiative. So again, this proves that even those with different political ideologies can come behind a common sense approach to reenfranchisement. And this is also part of why people all over the country really celebrated Florida's historic win, which has resulted in the greatest number of people being enfranchised based on a single law, I believe, since the passage of the Voting Rights Act in 1965. Unfortunately, we're going to see whether or not that victory remains. And I say that because there were a number of bills that were introduced this legislative session that could create some roadblocks to its full proper implementation and the automatic restoration of voters. So one of those bills, Senate Bill 7066, has several provisions. I'm highlighting two of them for you. And it's not that, from SPLC's perspective and a lot of other organizations and voters, that the entire bill is, not the entire bill, but there are other parts of the bill that are very troubling with respect to rights restoration. But these are the two that I think create the greatest barriers or obstacles, not only for administrators of elections, but also those who are eligible under Amendment 4 right now. So the first provision noted here actually requires the supervisor of elections to make a final determination as to whether or not a person has been convicted of a felony offense. And while it is true that supervisors are the ones who play a role in determining a voter's eligibility, when it comes to digging through all of the criminal records that might be associated with someone's sentence, let alone multiple people's sentences, that I would argue becomes an unwieldy task and is beyond the scope of the role that supervisors of elections should be playing. To also dig behind the Department of Corrections, the Clerk of Courts, etc., to do the research and work of determining whether or not someone has completed the terms of their sentence, especially when the person should know whether or not he or she has satisfied his or her sentence. And the voter registration form includes an affirmation that you are signing this form under penalty of perjury and you are attesting that you are indeed eligible to vote. So this extra administrative or bureaucratic process not only holds up the supervisors from doing their jobs, they also unnecessarily hold up those who are now eligible automatically to vote, and could also have an impact on those who don't even have a conviction, but who have just gotten caught up in this registration scheme that has been just erected. The other troubling and confusing part of Senate Bill 7066 is that it states requires completion of all legal financial obligations, even if those obligations have been converted to a civil lien. And this is very troubling for a couple of reasons. One is that once it becomes a civil lien, you are no longer in the criminal justice system. This is something that courts have been doing in part so that people can move on with their lives, in part recognizing that some of these obligations are so huge and onerous that if we were to hold up someone's ability to reintegrate into society solely based on their wealth, then that reintegration would never happen. And then also in terms of financial obligations, that it can be very messy in terms of what someone's financial obligations are, what's associated with their sentence, what's considered really restitution or a court fine or a fee, the documents. You have some courts who, once they've converted financial obligations to a civil lien, are now issuing completion of sentence orders. And so you hopefully can understand that this situation or this law is creating a lot more confusion than Amendment 4 ever intended, a lot more confusion than I think supervisors of elections intended to be saddled with, and also undermines, I believe, the will and spirit, the will of the people who voted in favor of Amendment 4 and the spirit behind the amendment. Another troubling bill that was introduced and passed this session is Senate Bill 7096. Now, this is not a bill related specifically to Amendment 4, but it's definitely a reaction to the success during the petition gathering phase of Amendment 4. So like Senate Bill 7066, there are a lot of provisions in Senate Bill 7096 that are problematic, but two of the ones that I've listed here for you are, one, that it requires that petition gatherers register with the state and be a Florida resident for a specified period of time before obtaining signatures. There are a lot of issues with that, one being, of course, the right to travel. People are able to work outside of the states where they live. I would take the Georgia-Florida border as an example, the Florida-Alabama border as an example, the Georgia-Alabama border as an example, where you have people going back and forth, and yet to gather a petition, enough signatures for a petition, you have to be a Florida resident. The other problematic part of this bill is that it prohibits compensation for initiative petition gatherers or entities based on the number of petitions gathered. So the idea perhaps is that you just pay someone a flat fee and they get as many or as little signatures as possible, but I think realistically that's not how it works. Economic motivation has been recognized as proper in terms of getting as many signatures out as possible, and so to put a cap like that really hinders a lot of ballot initiative sponsors. Makes it difficult to be quite frank for some petitioner gatherers to even afford to do this part-time or full-time. And then the result, of course, is that these types of initiatives are less likely to make it onto the ballot in the process that I described to you earlier, let alone being passed like Amendment 4. So this, again, Senate Bill 7096 creates a lot of concern. And then the other legislation, which I would say thankfully did not pass but was introduced, was House Joint Resolution 57/Senate Bill 232. And this was a proposal to increase the numerical threshold for passage of citizen initiatives. This died in the Judiciary Committee. And the 60% threshold that we're currently working under is something that voters agreed was realistic, was reasonable. And so this proposal would be to increase that threshold to 66 2/3%. And remember that Amendment 4 was passed with 64.5% of voter support. So I think it's a little bit more than coincidence that this proposed increase in the threshold goes just beyond what was gained in terms of Amendment 4. So again, I mentioned these bills because we view it as a backlash in terms of Amendment 4's success, that it also is a forecast as to the difficulty that other ballot initiative sponsors, as well as voters who want to change Florida policy and have been unable to do it through the legislative process, the barriers that are being erected, and that if these barriers are erected, it really minimizes the check and balance that the ballot initiative process provides, which is, again, that voters should have an ability to directly influence what our Constitution looks like and what our policies are. So I am going to move to partisan gerrymandering. Now, there are two cases right now in the U.S. Supreme Court. One is a direct partisan gerrymandering case. That's the Rucho v. Common Cause, Lamone v. Benezik case. That is a challenge that I'll talk a little bit more about, a consolidation of two cases, one out of North Carolina, one out of Maryland, one involving bad acts on the side of the Democratic Party, one involving bad acts on the side of the Republican Party. And then the other issue which impacts redistricting and the census is Department of Commerce v. New York, which involves whether or not a citizenship question should be on the census form. So first, just a basic definition of gerrymandering. As many of you know, gerrymandering has existed essentially since the beginning of our democracy. And so it's the practice of setting boundaries of electoral districts to favor a specific political interest within a legislative body. And cases, going back decades in which the Supreme Court has really struggled with how far does the court go, or what role does the court play in terms of the drawing of district lines, what is a proper test to determine whether or not gerrymandering, whether it be political or partisan or even prison gerrymandering, has occurred. But for our purposes today, we're going to focus on partisan gerrymandering, which is an effort to increase the power of a political party. Again, a practice that has been in place since the beginning of the beginning of our founding. So in Russo v. Common Cause, I've provided you with the main issues that are presented in the case, just so you have a general understanding. But really, this case involves, again, Maryland and North Carolina. And in both states, the redistricting was done by a single party holding exclusive control over the drawing and implementation of the redistricting plans. In North Carolina, the record shows that North Carolina's 2016 congressional redistricting plan was drawn with the explicit goal of providing a maximal and sustainable advantage to Republicans. There's no question about that based on the record. And in fact, one of the redistricting experts from the RNC, the Republican National Committee, admitted that his primary goal was to draw district lines so as to create as many districts as possible in which the GOP candidates would be able to successfully compete for office, and to also minimize the number of districts in which Democrats would have an opportunity to elect a Democratic candidate. The map makers also admitted and put in the record that they were creating a political gerrymander in order to help foster the election of Republicans, because electing Republicans, and this is a quote, electing Republicans is better than electing Democrats. And you also had one of the state representatives who stated that he intended to draw the maps to give a partisan advantage to 10 Republicans and 3 Democrats, only because he believed that it wouldn't be possible to draw a map with 11 Republicans and 2 Democrats. And then you counter what happened in Maryland, where you had Governor Martin O'Malley, who testified that he set out to draw the borders in a way that was favorable to the Democratic Party when creating Maryland's 2011 congressional districting plan. And he also readily admitted that the intent was to create a map that was more favorable for Democrats over the next 10 years and not less favorable to them. You also had an analyst from a political consulting firm to the Democratic organizations who acknowledged that he was given the dual goals of protecting Maryland's incumbent Democratic representatives and changing the overall makeup of the congressional delegation from 6 Democrats to 2 Republicans, from 6 Democrats and 2 Republicans to 7 Democrats and 1 Republican. And then finally, the governor also testified that he considered gerrymandering to flip either the 2 districts at play there to Democratic control, but decided to go for one of the districts because just in terms of the geography, it wasn't possible to get both. So you see that in both North Carolina and in Maryland, the gerrymanders were specifically drawn to create maximum partisan advantage while minimizing potential risks. And really, the fact that these plans were eventually adopted, and I believe some elections took place under them, that they did achieve the legislators' intended goals. In North Carolina, the gerrymander produced 10 Republican seats out of North Carolina's 13-seat congressional delegation as intended, even though 53.22% of North Carolina voters statewide voted for Republican congressional candidates. And so again, you have 53.22% voting for Republican candidates, but Republicans maintaining 76 remaining or increasing actually their representation in the North Carolina delegation to 76.9%. You had Democratic voting strength was packed into 3 districts. And so, again, you're looking at how the districts were what we say cracked to spread out certain political voters, or packed to make sure that their ability to elect candidates of choice was minimized. And then in Maryland, the same thing, the goals were achieved. The existing Democratic districts remained safe, and the district at issue was flipped. Whereas it had previously elected a Republican candidate by a margin of about 28% in 2010, you had a Democratic candidate who was elected in 2012 by a margin of 21%. So again, I think that these cases are important for several reasons, two of which are, first, of course, we're heading into a decennial census where I would call these kind of shenanigans are destined to occur again. And we really need some clear guidance from the Supreme Court as to the proper test to use in analyzing these types of cases. The court punted in a case out of Wisconsin called Gill v. Whitford, and determined that the plaintiffs there didn't have standing to challenge the configuration of districts where they did not live. And so these two cases are an effort to really push the court to finally give us a workable test, whatever it ends up being. And then I think that these cases are only great to the extent that they expose that neither political party, unfortunately, is above partisanship. We recognize that, each party has their ideology and their goals, but the real goal should be to protect the principle of one person, one vote. That's a principle that comes out of the 14th Amendment as the Supreme Court has interpreted it. And so it's not about electing the highest number of Democrats or highest number of Republicans. It should be about making sure that each voice, each vote is protected and has an equal vote has an equal voice in the process. And that truly represents at least the political leanings of a majority of the state's citizens. The second case here is Department of Commerce v. New York. Now, this again, multiple issues presented. I laid them out for you just so that you could have an idea of, all that has been presented in this case. But our major concern right now really has to do with whether or not this citizenship question actually makes it on the census form. As I mentioned in my introductory remarks, Southern Poverty Law Center, we have an immigrant justice project that works closely with immigrant communities, mixed status families in terms of families that are, U.S. citizens or green card permanent residents, and those who don't have legal status. And we also work closely with other groups that service the immigrant population, like the Florida Immigrant Coalition and a group called Mi Familia Vota, as well as a Miami-based Haitian organization run primarily of women. So I reference those groups because they can certainly attest that the anti-immigrant sentiment that they are feeling is real, that including this question on a census form, which is supposed to have the real sole purpose of getting an accurate count of how many people are in our country, will have a chilling effect, that there's been no evidence of non-citizens voting, definitely not intentional on the broad scale that's been presented through arguments of voter fraud, and that if we don't get an accurate count, it could really impact Florida, which is slated based on our estimated population growth to gain 2 congressional seats. And so, again, the main argument of the plaintiffs in this case is that including that question will discourage certain people from filling out the form at all. And that will result in a severe undercount, which will make it more difficult for states like Florida perhaps to justify why an increase in their congressional delegation is necessary. And also, as we know, the census also plays a role in terms of funding issues. So you have communities that have a significant population, but if they're not accounted for in the census, are not going to get the same federal and state dollars needed to run their infrastructures properly. So we've had oral arguments in both of these cases, like several of the cases pending on the Supreme Court's docket. We expect a decision in June. And so I see that our time is going, so I want to get through a couple of these slides, next couple of slides quickly. So first, I did want to talk about election administration. There are a lot of issues that come under election administration, but I would say some of the main ones are voter registration, voter purges, vote by mail ballots, which originally in Florida were called absentee ballots, and then provisional ballots. So in Florida, our registration numbers show that you've got about 4.7 million registered as Republicans, 4.9 registered as Democrats, and a significant number of 3.6 who are registered as no party affiliation. So efforts to increase voter registration have included what we now have, which is online voter registration, which has been wonderful. Successful suits to extend voter registration deadlines that have come and gone during a hurricane cycle, as well as efforts to have same-day voter registration, in part as a response to the hurricane season and other issues that come up in people's lives that make it difficult for them to register in advance, even though they still want to participate in the elections. Voter purges. There have been lawsuits filed by organizations claiming that certain election administrators are not properly cleaning up their rolls as required under the Help America Vote Act, known as HAVA, which does require list maintenance, but it doesn't require or support wholesale voter purges without proper investigation. And so a couple of years ago in Florida, for example, under that previous governor's administration, we had almost over 100,000 people who were purged from the voter rolls, coincidentally, the majority of them having Spanish surnames. And after serious pushback and backlash, that number was significantly reduced, I think into the ones, in terms of who ultimately was justifiably purged from the voter roll. So that is an issue of serious concern, especially when people show up to vote and they're told that their names don't appear. In terms of vote by mail ballots, when I was with the ACLU, we prepared a report with a professor from the University of Florida that revealed that there was a serious lack of uniformity in how vote by mail ballots are being processed to determine whether they're invalid, to allow for a curing process, and that especially younger and racial and ethnic minority voters were much more likely to have their vote by mail ballots rejected and less likely to be informed at all, or at least timely informed, of their ability to cure whatever problem was recognized in their ballot, usually due to a signature issue. So one of the main recommendations that came out of that report is that there be some uniformity, both on the supervisor of election side, but that the legislature really take the mantle in creating some of that uniformity to avoid what we saw not only in 2018, but 2016, and hopefully not in 2020. And then just quickly, provisional ballots. I think we know that, this was a provision that comes also out of the Help America Vote Act. It was supposed to be a safeguard to make sure that if there were any issues at the polling place, people could at least cast a ballot. But now many believe that it's being abused. Either people are not being offered a provisional ballot, or they're being given provisional ballots when if a little bit more work were done at the polling place, they should be getting a regular ballot, and that some of those ballots are not being counted at all. In terms of community engagement, as I said, I think that lawyers have a role to play, not only in terms of the educational component that we can provide, but also making sure that, especially when it comes to the free speech aspect of this kind of engagement, that those rights are protected. We still have a lot of the traditional models being used in terms of the door knocking, the flyer or leafletting, the TV ads, and I'm sure you all are inundated with during election season, and then of course attendance at community events. For most, especially in urban areas, there's usually a registration table encouraging people to sign up. But you also have more models or and advancements that are trying to be made, especially for use in 2020 and beyond. So we're seeing a lot of increase in the use of social media, a lot of targeting of a younger demographic. As I said, Florida passed online voter registration, so encouraging people to use that, and then also same-day registration, which we're still pushing for. So with 1 minute to go, conclusion, 2020 and beyond. These are issues that continue today. SPLC and several other organizations are working very hard. Got a number of members of the private bar who have really stepped up to assist voters in protecting their rights. And again, I just thank you all for your interest and your support in terms of these issues. And hopefully we can all work together to make sure that these problems are addressed. Thank you.
Wonderful. Thank you very much, Nancy. We appreciate your time today. John is going to put up a slide that has the CLE information for today, as well as information on how to join the Public Interest Law section. If you're not already a member, we would love to have you join. Nancy, we did not have any questions for you. And thank you all very much for your attendance today, and a special thanks to Legal Services of North Florida, who is our partner in hosting these webinars. Hope you all have a good day. Please join Public Interest Law section and have a great day. Thank you.